the Financial Institution Recovery Ordinance 2001. As we have gone through Section 9 of the Financial Institution Recovery Ordinance, which pertains to filing of recovery suit against the borrower, the guarantor, or the mortgagor. The suit also can be the suit can also be filed by the borrower, mortgagor, and guarantor against the financial institution as per Section 9 of the Financial Institution Recovery Ordinance. Thereafter, we have gone through Section 10. If the notices as per Section 9 of the Financial Institution Recovery Ordinance have been served, so defendants are given an opportunity to file application for leave to defend the case. When the leave to defend application has been filed, and as per Section 10(4) of the Financial Institution Recovery Ordinance, the defendant has to give a breakup that how much amount he has availed, how much amount he has repaid, and how much amount he has to repay, the outstanding amount, and what is the disputed amount. So if there is an admission, in the leave to defend application, so as per Section 11 of the Financial Institution Recovery Ordinance, Banking Court is empowered to pass an interim decree against the defendants on the basis of admission. So if you see in CPC, Order 12 Rule 6 CPC, when a written statement has been filed, and in the written statement, if the defendants admit some claim or some portion, so the suit is decreed on the basis of admission. So I will read first Order 12 Rule 6. What does it say? Any part may at any stage of the suit where admission of fact have been made, either in the pleading or otherwise, any apply to the court for this judgment or other or order as upon such admission he may be entitled to without waiting for the determination of any other question between the parties, and the court may upon such application make such order or give such judgment as the court may think fit. But in Financial Institution Recovery Ordinance, there is no need of filing an application under Order 12 Rule 6 CPC. Straight away, if the court sees that there is an admission by the defendant, so court can decree or can pass an interim decree up to the extent of the amount which the defendant, guarantor, or mortgagor has admitted that such and such amount is outstanding against them, and leave to defend may be granted conditionally, so as to deposit the amount which they have admitted. So now I will read Section 11 of the Financial Institution Recovery Ordinance. If the banking court, on a consideration of contents of the plaint, the application for leave to defend of the defendant and apply thereto, is of the opinion that the dispute between the parties does not extend to the whole of the claim, or that of the claim is either undisputed or is clearly due, or that the dispute is mainly limited to a part of the principal amount of the finance or any other amount relating to the finance, it shall, while granting leave and framing issues with respect to the dispute amount, pass an interim decree in respect of that part of the claim which relates to the principal amount and which appears to be payable by the defendant to the plaintiff. So now, as per Section 11 of the Financial Institution, the court is empowered. The court can pass an interim decree of that claim which has been admitted by the defendants, or grant conditional leave to defend for depositing that amount. But on the other hand, if the suit is filed as per CPC, so as in that case, on the admission, we have to file an application under Order 12 Rule 6 CPC. But here, the banking court is empowered if it sees that the amount has been admitted by the defendant, can pass an interim decree. So, as per Section 11(2), which I am reading, the interim decree passed under subsection 1 shall for the purpose including appeal and execution be deemed to be decreed passed under this ordinance, and any amount recovered thereby or recovered in execution thereof shall. I am repeating section 11(2) again. The interim decree passed under subsection 1 shall for the purpose including appeal of and execution be deemed to be a decree passed under this ordinance, and an amount covered thereby or covered in execution thereof shall be adjusted at the time of final decree. So if the decree is passed as per section 11(2), if the interim decree is passed by the honorable court and the honorable court grant permission leave to defend for the remaining portion or remaining claim, so the leave as the leave is granted and the matter will be fixed for issues and thereafter for evidence, so that part of interim decree at the time of final decree, that will be adjusted in that decree. So the amount has to be paid by the defendant if he admits the claim, and thereafter that interim claim will be adjusted in the final decree. So the interim decree is provided that it shall be open to the banking court, notwithstanding dependency of any appeal to modify in a part or in whole or reverse the terms of interim decree at the time of final disposal of suit, and pass such order as it may just proper. So it's also given the banking court, while passing interim decree, the interim decree can be appealable, and this decree can be reversed, this decree can be amended at the time of final decree or as per direction of the appellate courts. Provided further that neither a banking court nor a high court acting under subsection 3 of section 22 shall stay the execution of an interim decree unless the judgment debtor deposit in cash with the banking court the amount admitted by the judgment debtor to be payable to the institution. So, if an appeal has been filed under section 22, the Honorable High Court will not grant stay order in the matter until and unless the amount which has been admitted by the defendant is deposited in the banking court. The amount admitted by the judgment debtor to the financial institution, clause C of subsection 10 4(c). Judgment debtor to be payable to the financial institution under clause C of subsection 4 of 10 to furnish surety for the balance decretal amount, if any, inclusive in the case of suit filed by a financial institution, cost of fund determined under section 3 and other cost. So as per section 10.4 that has been if the defendant has admitted, so as per section 10.4 he has to deposit the admitted amount in the banking code, and that interim decree is appealable, and if the decree is the appellate court, the Honorable High Court can stay grant stay if the defendant judgment debtor deposited the admitted amount or in shape of a surety. So this was a section 11 of the Financial Institution Recovery Ordinance. So if you have any questions relating to section 11, you may ask in the comment box. So I will try to reply, or thank you. The